Welcome back to my YouTube channel, guys. My name is Saman Habibi, your real estate agent for the Durham region. I have with me Alex Henderson from MBAA Law. Alex.
Thanks, Saman, for having me. Like Saman said, my name is Alex Henderson. I'm a lawyer with MBAA Law Professional Corporation in downtown Oshawa. I've been a lawyer for about 5 years now. MBAA Law has been in the legal industry for, I think, about 100 years. So we've got a lot of experience at our office. I practice in the areas of real estate, employment law, corporate law, and we also do wills and estates as well.
Sweet. And the purpose of today's video is to talk about some recent trends in real estate and have a lawyer's perspective. We're going to divide this into two sections. We're going to talk about residential transactions, and then we're going to talk about perhaps what some investors are experiencing in the market and what recent transactions can mean to them. So we have a few topics that we're going to talk about. So shall we just jump right into it?
Let's jump into it.
Sweet. So I want to start off by talking about the day-to-day residential transaction for someone buying their dream home.
Sure.
So what are some recent trends that you're seeing in the market?
So right now, as most people know, inflation increasing, interest rates are increasing. The market is starting to cool a little bit. We're not seeing those crazy high prices that we might have been seeing earlier in the year. And so with that, we are seeing some issues with closings. A lot of buyers are requesting extensions because they need to get their financing in order and things like that. So we are dealing with more extensions than we would have been, say 6 months ago. Mm-hmm. So there's clearly been a shift, and it's causing a little bit of stress for buyers. Some buyers who signed their agreements, months ago are worrying, did we overpay for this property? And on the other side, sellers are also a little bit concerned about, are our buyers going to be able to close given that interest rates are going up and whatnot? So right. That's a pretty popular trend that we're seeing.
So in terms of extensions, I guess let's talk about it this way. When the topic of the extension comes up,
yeah.
From your perspective, or from the law office's perspective, do you guys like to complete the extension from the lawyer's perspective, or do you like to have the real estate agents deal with the extension?
That's a good question, and we get it a lot from realtors. It really depends mostly on if you're buying or selling. Mm-hmm. If you're buying, you generally want the extension to go through the agents. Just sign a quick amendment to change the closing date if you need a bit more time. If you're selling, you have to think about the costs that you're going to incur if you do extend. So that means you're going to have to keep paying interest on your mortgage. If you have a bridge loan, you have to pay interest on your bridge loan. There are other costs that you might be incurring as well. Mm-hmm. If you're selling, you probably want to go through a lawyer to deal with the extension because your lawyer is going to help you recover those costs, or at least attempt to recover those costs.
Right. Okay.
Yeah.
And then what about in terms of, so let's say you're the seller, right? Mm-hmm. What practices are in place to protect the sellers? So, for example, can you request additional deposit money? Can you request that if they don't close by the new agreed upon date, that the buyers forego the deposit and the seller gets the deposit? Are those options on the table?
Yeah. So how aggressive you want to be with your extension terms really depends on, number one, the lawyer that you have, but also the length of the extension that the buyer's requesting.
Yeah.
If the buyer's asking for another month to extend the closing, with the market that we're in, you have to consider about, if they can't close within a month, what's the value of my property going to be at that point in time? So you're going to be more aggressive with your extension terms depending on that factor mainly. But one of those items that we do often insert in our extension terms is an additional deposit. And then at times we've also inserted a provision that if they can't close on the new date, they agree to forfeit all of those deposits to the sellers, and that way the sellers at least have some security that if they can't close, at least they'll get the deposit back.
In the event that, let's say, a deal does fall through, and the sellers now have to get their house back on the market to try and resell, make a reasonable attempt to market it and sell it properly. If there's a loss that is incurred in the new transaction, not sure if you guys have dealt with it recently, but do you know typically what that process and the timeline is to recoup losses?
Yeah, so that's a really good question. Unfortunately, we are seeing it more, and we are dealing with some at our office right now. We've had sellers relist their property and sell it for $300,000 plus, less than what the previous purchase price was for.
Yeah.
So those are damages.
Yeah.
The buyer breached the agreement, and therefore the sellers have now suffered damages for the difference in the purchase price. They've had to continue paying the mortgage, all those sorts of things.
Yeah.
And those are recoverable. The way you go about recovering that is through a claim. So you'd issue a claim against the buyers, the former buyers, and take it from there. A lot of the time, those claims are settled or resolved by way of what's called a summary judgment motion, which is basically, without having to go through the expense and trial, it's almost like an expedited trial. You bring a motion to try to get a much quicker result without going through all the time and expense. And then you can also deal with the release of the deposit as well as part of that process. Now, lawsuits are very expensive and they can be time consuming. So a summary judgment motion, it really depends a lot on the court where you're bringing the action. Sometimes you can get a result within a year. Sometimes it takes 2+ years. So you have to, these are all things that you have to, these are all, because of COVID, courts are really backed up right now, and we're just starting to eating away at that backlog.
Right.
So that's something you need to consider. If I'm going to sue this person, it could take a year, 2+ years out of my life. It's going to be very expensive and very stressful. So is it really worth it for me? And again, it really depends on the facts. How much are you out because they breached the agreement? If we're talking hundreds of thousands of dollars, it's probably worth it.
Yeah.
If we're talking tens of thousands of dollars, maybe not.
Right.
And usually they're resolved without having to go to court, Saman. A lot of the time you reach a settlement without having to take it that far with the other side. There's compromise involved in that, but it's usually, to most sellers, it's worth it to settle for a bit less rather than having to go through the whole court process.
Okay, and if you were to go through the whole court process, let's say it is worth it in this transaction to go through. Do you typically have the lawyers on retainer? Like, I know each law firm could be different on how they handle it, but is there typically a retainer that you give, or is it like an hourly fee that you get charged?
That's a good question too. It really depends on the law office. So there are offices that operate on a contingency basis.
Right.
So that means that maybe you pay a small retainer or no retainer up front, and then when the matter is resolved, be it through settlement or a court judgment, the lawyer will take a certain percentage of the resolution. What most lawyers typically do is they require a retainer up front, and then they just bill based on their hourly rate. That's generally how our office practices. But it all depends on the lawyer.
Okay, cool. Good stuff. So maybe this might be a good time to just to note to our viewers that what we're talking about is not legal advice,
right?
And to discuss with your own legal team on any issues that you may face.
Right. Absolutely.
Okay. So next topic. So on the topic of residential, so let's say you have purchased a property. Let's just say you purchased it in a winter month when there was snow in the backyard.
Sure.
Closing is 3 months out, snow melts, you go for a revisit, and you find cannabis in the backyard. And let's talk about if you had a clause in your agreement of purchase and sale saying that there is to be no cannabis on the property, or if you forgot that clause and you don't have it. So what happens in those scenarios? Because, although yes, it's legal now up to a certain limit, some people don't like it, some people don't mind it.
Right.
So what happens in these scenarios?
Yeah, it's a tricky situation, and you're probably going to get sick of me saying this, but a lot of the answers I'm going to give you are going to start with it really depends on the situation. So like you mentioned, a lot of agreements have a clause in there that states that the seller's not aware of the property being used for any illegal or criminal purpose like a grow-up. If you have that clause in there, great. The buyer can likely rely on that if they want to back out of the agreement, but again, it really depends. They may not want to back out of the agreement. They want to negotiate, a reduction or whatever the case might be. So if you run into a situation like that, best thing to do is to, number one, contact your lawyer to figure out what kind of resolution you would want to have in that scenario. In terms of stigmatized properties, it's a little bit of a gray area in terms of even if a seller is aware that a property was a grow-up in the past or there was some sort of other stigma like a murder or a suicide at the property, the law in Ontario is technically, as it stands, doesn't require a seller to disclose that information to the buyer.
Right.
There's an ethical side to that, which is, well, if the seller is aware of it, some people would argue that they should. And I know for agents like yourself, it's generally recommended on an ethics basis that you do disclose something like that to the other side.
Yeah.
It's a tricky situation. And so depending on the nature of the stigma, if it's a grow-op, if you find cannabis, talk to your lawyer about it first, figure out a resolution. You may not want to back out of the deal. And you also have to consider what issues are there going to be if I need to, get a mortgage for this property. If the bank finds out that this property was used for some sort of illegal purpose or was a grow-up in the past, am I going to have a problem getting a mortgage through that lender? So those are all things you have to consider. So really, if you run into that situation, all I would say is contact your lawyer first, figure out how you can go about handling it.
Okay, so you made a good comment there. You said the clause may say no criminal activity.
Yeah.
So is cannabis considered criminal?
I would say no. So I mean, well, it depends. Again, if the amount is within the legal household limit, then no. Yeah. I would say it's not criminal. You don't have anything to worry about. If you don't like that there's cannabis on the property, well, when you move in, just dig it up and throw it out, or whatever you want to do with it.
Yeah.
But the case is, no. If you walk in and you go and you discover an entire field of cannabis, that's a different story. Obviously, if the person who's using it, and again, I'm not a cannabis lawyer by any means, but I would assume if they don't have the proper approvals and licenses to grow that much cannabis on their property, marijuana on their property, then it probably is an illegal operation, and you might have to consider it. Again, it really depends.
Yeah. Okay. No, that's fair.
Yep.
So on that topic, let's talk about buyer beware. So in Ontario, and I know that in a lot of real estate training seminars, when the ones that we attend, we talk about this concept that in Ontario it's buyer beware. So if you're working with a buyer client, it's up to us to dig and investigate for any type of information that might have an impact on for our buyers. So can you talk about the concept of buyer beware?
Sure.
And what does that mean? So let's say in the scenario of the cannabis, right?
Yep.
So if the buying agent didn't ask those questions, is the buying agent liable for it? Or
right. So agent liability, I wouldn't think so in that scenario. Again, it really depends. But buyer beware is basically a concept that if you're buying a piece of property, it's up to you to make sure that you know everything about that property that you're buying. You can't rely solely on everything that's been told to you by the sellers. So that's why we have clauses and agreements for inspections and all that sort of stuff, to make sure that you know exactly the state of the property that you're buying. There are some instances where buyer beware may not apply. So if you move into a property and you find out that a certain defect was covered up likely by the previous owners, that's a different story. You may have some legal recourse in that regard. Those are called latent defects. Right. That's not, basically it's any defect that you would not have uncovered had you had even if you had an inspection done. Okay. So if they painted over mold or something like that, for example. It's a really case-by-case basis, but you're right. The general rule is buyer beware. And what a lot of clients often wonder is, well, if the listing says one thing about the property, can I rely on that to try to get out of the agreement? So square footage, for example. Right. The listing says a property is between 2,000 and 2,500 square feet. You move in and you find out that it's only 1,600 square feet. Do you have any recourse to rescind, is the legal term, the agreement, and get out of the transaction? Most cases, I would say 99%, I would say no. The listing isn't your contract, generally speaking. The agreement of purchase and sale is. There are some cases where that exact situation has happened, and because of the facts of that case, the court actually ruled in favor of the buyer and allowed them to rescind the agreement. But the general rule is buyer beware. So if you run into a situation like that, again, because it's so fact-specific, you really just want to contact your lawyer, and figure out what sort of recourse you would have.
Yeah, that's a good point you make, that you're purchasing not based on the listing agreement, but based on the agreement of purchase and sale. And the agreement of purchase and sale excludes some information such as number of bedrooms, number of bathrooms, the square footage, the year of the house. So Those are important to note. Okay, awesome. So on maybe on that topic, now that we're done with that topic, we can move to investment properties because
Sure.
I think I do have more viewers who are of the
100%.
investor focused. So I find that when I speak to investors, typically they either purchase a property, do it and manage it on their own, or they buy a property and they soon find out that it's more than they can handle. They bring on a partner. And then after the fact, they like to work out some sort of agreement where they're going to bring in a working partner who's going to manage this process. After the property's done, essentially, from what I've seen, what people like to do is bring in a partner. Partner drives the project to the finish line.
Sure.
Once the project's done, you do a refinance. Once the initial purchaser takes all their capital out, they become 50-50 partners. The way I've seen it done is with like a co-ventureship agreement or some sort of partnership agreement. So maybe touch on that. Is there a standard agreement that you guys have for people to take advantage of? And how do you actually go about registering this on title? So if you're, let's say, the working partner, how do you go about registering this on title to make sure that you're protected? Or can you do that?
Well, yeah, that's a great question. So I'm going to say that if you're ever considering entering into an arrangement like you've described, partner A, partner B, you want to put that arrangement in writing in some form. Handshakes lead to headaches is what I like to say to clients. If you just have a handshake agreement, it's probably going to cause you problems down the line if you don't commit it to writing. And so there are a few ways that you can commit things to writing in that scenario. One is just a simple, well, not simple, but a co-ownership agreement. That sets out, if the property is sold, person A will receive X amount, so maybe they recover their initial investment plus anything extra, and then person B would receive Y amount. That's another way to go about it. It could also set out who pays for what expenses on the property and things like that. That's something our office has handled before. Joint venture agreements aren't so different, but generally speaking, they're a relatively new concept legally. They're not as regulated as a partnership or a corporation would be. Usually the only legal item that needs to be reviewed if there is an issue is that contract, the joint venture agreement. Basically what that sets out is very similar to the co-ownership agreement, but it's generally limited to a single project. So if there's a single property that these two individuals or these two companies are working on together, the joint venture agreement only applies to that one. Another option, as you mentioned, is the partnership agreement. Now, partnerships there is legislation that governs how partnerships operate. It might make more sense to operate under a partnership, but you have to consider the tax consequences as well, not just the legal consequences. So partners under a partnership are still each personally liable. So that's a consideration. And so if they're trying to avoid liability, then what some clients might want to do is form an actual corporation where each of those individuals are shareholders, and then enter into a shareholders agreement, which sets out exactly what their rights and responsibilities are, how they can buy each other out, so on and so forth. But incorporating is expensive. It has its own set of tax implications. So whenever you're considering something like this, what I would recommend to anybody is you want to consult with an accountant first to figure out what makes the most sense, and then consult your lawyer after to actually draft the agreement so that it lays everything out. In terms of your second question, about registering on title, there are some items that can be registered. So if you have, a certificate of pending litigation is basically where one person is alleging that he or she or a corporation has an interest in a property, and they're concerned that another individual who is registered on that property is going to be selling it. Person B wants to protect their interests, so what they can do is register, get an order for a certificate of pending litigation, which basically encumbers the property and makes it very difficult, if not impossible, for it to be sold until that item is dealt with. So that's one option. It just really applies to the facts of each case. Okay.
So now let's say you're in this partnership. For a very long time, things have been great in Ontario and in Canada. Prices have always gone up. But let's say we're in a market now where perhaps prices are declining. One partner has a family situation and they need out. And let's say one scenario, they don't agree to sell. What do? They agree to sell, you incur a loss, but that creates conflict, what happens?
Right. So that's exactly what I was thinking of. And we've seen that people buy a property when the market is very hot. The market cools down, and person B needs to get out for whatever reason. How do they go about doing that? Well, the agreement, whatever it is, if it's a co-ownership agreement, joint venture agreement, partnership agreement, or a shareholders agreement, would set out exactly how person B can get out of the arrangement.
Okay.
If there is no agreement, I can almost guarantee there's going to be some sort of conflict, and you may have to go through litigation to figure out exactly how it's going to be resolved. So you put it in writing to figure out, okay, well, if person B wants out, here is how they go about doing it. Here is the process. It very specifically lays it out and makes it very clear, so there are no questions if that is the case, and that does happen.
Right. So I guess it really comes down to the wording of the agreement, and typically before you enter into this partnership, there would be clauses in there saying in the event that there's a disagreement, you bring in a mediator or...
Exactly. So in the case of a corporation, for example, a shareholders agreement often sets out a right of first refusal, for example. So if person B wants to maybe sell their shares in that corporation to a third party, person A actually has the option to purchase those shares for the same price. So that person A becomes the sole shareholder. That's one example. Partnership agreements operate, and they have similar clauses, although we're not talking about shares in that situation. So yes, the agreement would, if it's well drafted, set out exactly how person B can get out of the arrangement and move on.
Okay, cool. Okay, awesome. And then with investors, typically there's contractors involved. From my experience, people typically don't have agreements signed with contractors, or if they do, it's, give me a quote, and that's pretty much it. So, what happened, or I guess, what would be your suggestion for working with contractors? Would you recommend having a standard agreement that you have your contractors sign? That's one question. And the second question is, what happens if the contractor says they're going to do a certain work? Let's say they've taken 50% of the money from you, but they haven't completed 50% of the money. I know 50% is judgmental on how you arrive there, but what happens in a scenario where you've given them money, but they haven't completed the work and they've kind of left?
So the first thing I always suggest to clients is before you hire anybody to do work on your home or an investment property, do your research first. There are a lot of resources out there, thankfully for the internet, that allow you to hire a contractor with some peace of mind. So HomeStars is a website I can think of, for example, that lists a number of reputable contractors. So that's number one, do your research. Number two, if you hire a contractor and you wind up in a situation like that, contractor has said they will do work, they don't do it, or they do half of it and then they walk away from the job. Well, what do you do then? Generally speaking, what I recommend to clients is first threaten to involve a lawyer and see if that's enough to get the contractor to return and finish the work. And then if they still don't, well, do involve a lawyer. So clients have called my office, we've sent demand letters to the contractor, and attempted to contact them and get them to come back and do the work. What you'll often find in those situations is contractors have a different side to they have a different version of events. So you're dealing with the contractor might claim that they're owed money and therefore that's why they walked off the job, whatever that case might be. So it really depends on the facts, but if you send a well-worded demand letter from a lawyer, sometimes that's all you need to get a contractor to come back because they obviously don't want to be sued. If they continue to not return or ignore the lawyer's emails and letters, the next real only option is to sue that contractor. And you can't sue a contractor or anyone until you know what your damages are. And you figure out your damages in that situation by, okay, well, the contractor did shoddy work. I have to hire a third-party contractor to come in and correct all those deficiencies and finish the work. Those are costs you wouldn't have incurred if the original contractor had just done the work, right? So those are your damages. Figure that out. Once you figure out what your damages are, determine if it's worth you bringing a claim. So like we were talking about earlier with failed agreements and transactions, whenever you're considering a lawsuit, you have to think, okay, is it really worth my time, energy, and money to bring this claim, or is it better if I just leave it? It really depends on the individual and the facts of each case, but if you're out tens of thousands of dollars, you may want to bring a claim. You just need to be prepared for the possibility that in response to that claim, the contractor might allege that you owe them money, might place a lien on your home, that can impact whether you're going to be able to refinance or sell your property.
Right.
These are all things you need to consider. So the first step that I generally recommend is reach out to a lawyer, get the lawyer to send a letter and take it from there. Yeah.
Awesome. All right, guys, thank you very much for watching. My name is Saman Habibi, and here we're with Alex Henderson. And if you guys have any specific questions, you can drop them in the comment section below, or Alex's contact information is in the show notes and you can reach out to him directly. And guys, they are local. They are in the Durham region and in Oshawa. So if you have a closing coming up, feel free to reach out to Alex and he can guide you on how they can help you out.
Awesome. Thanks for having me, Saman.
Thank you.